Dear Yuval Shani, Professor Yuval Shani, liebe Freundinnen und Freunde der Hebräischen Universität Jerusalem. Thema des heutigen Abends ist die Rechtsstaatlichkeit in Zeiten schwerster Krisen. The rule of law in times of deep crisis. Professor Matthias Mahlmann möchte ich sehr für die umfassenden Vorbereitungen des heutigen Anlasses und die Gastfreundschaft hier an der Universität Zürich danken. Diesen Abend verstehe ich insbesondere auch als Unterstützung der Anstrengungen und des bemerkenswerten, engagierten und ehrlichen Einsatzes von jenem Israel, das sich für eine offene, demokratische Gesellschaft einsetzt. Die Publikationen und Bücher von Yuval umfassen außerordentlich viele Fachbereiche. Sie reichen von Human Rights Fragen, auch Geiselfragen gehören leider nun dazu, über Beurteilung der Effizienz von internationalen Gerichten bis zu internationalem Recht im Bereich von Cyber Security und auch von Online-Plattformen. Wie Sie alle bin ich nun sehr gespannt auf die Ausführungen der Referenten und auf das anschließende Podium.
Ladies and gentlemen, everybody present, the rule of law is usually divided into a formal and a material substantive conception. The formal conception concerns such characteristics of law like certainty, non-retroactivity, certain amount of clarity connected to the certainty of the law, public promulgation, equality before the law, and a few other of these things that are relevant in this formal sense to qualify something as a law in the context of the rule of law or Rechtsstaatlichkeit in the German-speaking world. And these formal categories have already, I think, an obvious material, substantive point. They are not just there for themselves and because it is helpful to have these particular categories to organize a society rationally, but they serve a substantial normative idea. And this substantial normative idea that these characteristics serve are, first of all, freedom and autonomy. So the rule of law is a tool designed by human beings over the history to protect these very important values. Because only if you are living in a framework of certain and mildly precise and non-retroactive public rules, you can actually live as a free and autonomous being. These rules also serve the value of equality. Equality before the law is an evident and bedrock principle of the rule of law. And the abstractness and generality of law is an essential tool to create equality within a legal community. They do not necessarily guarantee equality already, but they are certainly a central precondition to have something like equality in a legal community. The third, I think, important value the rule of law serves is actually human dignity. And that is true not only in an ornamental, rhetorical sense, but I think in a very precise sense, if one thinks about the normative content of human dignity. Human dignity is about protecting us in our status as a subject, as an agent, as an author of our life, and the rule of law enables us to be exactly that. If we are living in an order where we are not relying on certain rules, but dependent on the whims and the moods of some ruler, the arbitrary rule of some powers, we certainly cannot protect our subjectivity and our claim to be masters, at least to a certain degree, of our lives. So these important substantive elements are central, and they already indicate that a central function of the law is actually to protect these values that are relevant. They also serve, these principles of the rule of law, to protect others. against harm. But they also do something equally important, namely they protect ourselves. Because without the rule of law, harmful acts can be committed. We may be carried away by certain passions, political passions that can be forceful. And the rule of law is a tool to prevent that to happen, to protect, perhaps, if you will, our better selves. I think that is one of the central lessons of dictatorships and totalitarian systems. They force people in complicity with harmful and immoral, sometimes even criminal acts, and thus corrupt the beings that are part of these systems. An interesting example for such mechanisms is, and you may remember that story from one of the greatest novels of the 20th century, Life and Fate by Wassily Grossman, where he describes how his main actor, a Jewish ingenious scientist, signs the letter that Stalin drafted or let be drafted, denouncing the Jewish doctors when in the Stalinist dictatorship, anti-Semitism became a political doctrine. That mirrors the story of Grossman himself, who was a very courageous voice as a Jew himself against anti-Semitism in the Stalinist dictatorship, but also signed that letter and never forgave himself for doing so. So I think that is an important reminder that we should certainly not overestimate the importance of the law, but it can be a tool not only to protect values, to protect others and prevent harm being done to others, but it may also be an important tool to protect the moral integrity of ourselves. The rule of law is an aspiration, both a national and international law. The many institutions in our political communities serve these aims, as do the various norms that exist on different levels, from the Constitution to certain administrative acts in concrete situations. And of course, a central element of this rule of law is a judiciary, more precisely an independent judiciary, a judiciary that is not just a puppet of political forces. And that independence was obviously one of the central concerns during the, and still in a way, ongoing fight against these legal reforms against which so many people in Israel protested. The rule of law is also, I would maintain, an aspiration of the international rule of law, despite, of course, the international rule of law is of a much more precarious, fragile character, both as to the creation of law, because there is no central legislature that could create such laws, because of the problem of enforcing such laws if they exist, and the problem of jurisdiction, of the limited ability of courts, international courts, to actually enforce some of these rules. But still, I think it is very important to underline that behind this international system, the aspiration that it embodies, a very important and precious idea is hidden. You may have come across the words of the chief prosecutor of the Nuremberg trials, Jackson, who commented, and I think that was not just rhetoric at the beginning of this trial, who commented that a very particular thing had happened because of the creation of these Nuremberg trials, namely that the Allies stayed the hand of power and created this court. And staying the hand of power, he said, was one of the most significant tributes power has ever paid to reason. And I think there's a very important point here that Jackson says, and I think the Nuremberg trials underline this despite the flaws that they may have, namely that it is possible to stay the hand of power. And power is seductive, especially supreme commanding military power may seduce you to use it without restraint. And to show this restraint, to rely on the complicated path of the law is certainly, I think, great achievement of that particular historic event. My last point concerns the testing case of our commitment to the rule of law. The rule of law is something that has a price tag. We have to pay something for the rule of law, and not just because you have to pay judges, administrators, and even perhaps most grudgingly, law professors. The price tag runs much deeper, and namely we have to compromise with many of our aspirations. The criminal law is a classic example. Sometimes counterintuitively, we accept that we only want to sanction human beings if certain normative conditions are met. We don't want to sanction them at all costs, only if proven guilty. And sometimes, as you all know, it is not so easy to actually cross that obstacle. And sometimes one has to compromise one's desire for perhaps a justified sanction because it is central to accept these particular normative constraints. That is also true for any kind of everyday legal struggle. Perhaps you are having the pleasure at the moment to go to court occasionally and see how slow the whole process develops, that it can drag itself out over a long time, sometimes years. It is costly. It doesn't produce always convincing results. And it is certainly something not self-evident that we rely on this system, that we create these structures, that we maintain them, and we maintain the, I think, complicated truth behind this bit of, I think, institutional wisdom. That, of course, concerns also the laws of war. They also, with their limited applicability, create certain constraints on what you are allowed to do, even if some powerful imperatives may point to other directions. I think this self-restraint and the price you may pay has a deep point. I would like to mention here an insight that you find both in Hugo Grotius and in Immanuel Kant. In Grotius' reflections about the laws of war and public international law in general, and Kant's reflections about perpetual peace, something that seems today very remote indeed. One of the points both were making was that it is important to think about the ways we conduct wars, because any war must be conducted in a way, they thought, that leaves the possibility of peace open, that doesn't preclude a peace after the hostilities have ceased because of the way the war was conducted. Kant also thought, and I think that's a very important thought in I think more than one dimension, that what he called the pursuit of the justice of practical reason is a central path to peace. So the aspiration to a just order, perhaps even something remote like a just international order, may also deliver the benefit, he thought, and I think he has a point here, the benefit of peace. So I think the rule of law is a complicated cultural product, something that needs restatement again and again. something that needs restatement, in particular in times like ours, where many crises are challenging our own political perceptions. But I think it is worth it, and the price is worth it that we are paying here. And if we adhere to these standards, perhaps a world beyond these crises is less far away than we all may think. So because of that, and because of the problematic situation we are in, I'm very happy that so many people came to this event and decided to listen to some of the thoughts that are here presented and to contribute perhaps to the discussion that we are having afterwards. This, ladies and gentlemen, dear everybody here, was the worst part of this evening. Now the better part starts, namely the presentation of Yuval Shami, and I'm very much looking forward to his comments. Thank you very much.
Thank you very much. Thank you very much, Professor Melman. We'll see about the best or worst part in a minute. I also want to acknowledge the Swiss friends of the Hebrew University and Ms. Nadia Benzini for inviting me here. And also thank Judge Rothenberg for agreeing to moderate this meeting, and also thank Dean Gatcher and Professor Keller for coming. And I also want to acknowledge the presence of my professor from Hebrew University, Ruth Lapidot, with whom I studied international law 30 years ago. And I'm still learning a lot from her, and I'm glad that she's here with us here in Zurich. So I will try to continue from where Professor Melman has left off, but perhaps first I will say also a few words about what I consider to be the main significance of the rule of law, and then I will discuss how it is impacted by times of deep crisis, as the times that we are confronting in Israel, but in Europe and in many other places around the world. So I fully agree with the way in which Professor Melman has defined or has introduced the rule of law as a basis for a contemporary liberal society, which serves as a key safeguard for very important values such as liberty, human rights, democracy, and good governance. At its core, the principle provides that everyone within a state, and perhaps also within an interstate context, including persons in positions of authority, are bound by the law. In other words, no one is above the law, and everyone is entitled to protection under the law, and everyone is expected to be treated equally before the law. So in that respect, it is a manifestation of the principle of equality of all citizens, which underlies not only human rights, but also democracy. The reason why we have a one person, one vote system in a democratic country is that because we believe that everyone is equal. And it is also tied, the principle of a rule of law is also intimately tied to another very important democratic ideal, and that is that the government is there in order to serve the common good of the people. And this idea is the idea that Lincoln articulated at the time in his famous Gettysburg address, and that is that we are expecting a government of the people, by the people, and for the people. So the rule of law is the framework, is the societal framework that ensures that governmental power is exercised on behalf of the people, for the good of the people, and within the terms of a specific legal mandate, that is the legal authority that was conferred upon government by the legal representatives of the people, which would typically be the legislature. Like Professor Melman has said, and we will probably be discussing this further with Judge Rothenberg, in order for the rule of law to effectively operate, we also need those laws to be interpreted and applied by independent agencies, namely not the cats that are guarding the cream, not the government itself. And that would be prosecutors, independent prosecutors, independent judges, independent police officers, independent other law enforcement officials. Without such effective and independent oversight, the rule of law becomes illusory. And like Professor Mellman has indicated, in order for this framework to operate, this rule of law has to meet certain conditions. And some of those were already mentioned. Some of the conditions are procedural, namely that the laws have to be clear, they have to be accessible, they have to be publicized, they have to be introduced within what some people call a culture of compliance, and that is a social norm that people normally follow the law. There should be remedies available in the case that the law had been breached. The laws should aspire to be general in nature. They should apply in a stable manner. They should be non-retroactive, and also perhaps meet some substantive conditions such as a minimum degree of inner morality, such as respect for human liberty and dignity. So these were a few comments about what the rule of law is and what the rule of law serves and what does the rule of law presume. We are seeing the rule of law, however, encountering a deep crisis in Europe, in Israel, but also in North America and in other regions of the world. And that deep crisis has many reasons and many manifestations, but I will focus mostly on, in the interest of time, on two specific problems. One is political populism, and the other will be international conflicts. So with regard to political populism, this is a challenge that, like I said, is a challenge that we are seeing increasingly in different parts of the world. 2 days ago, a president had been inaugurated in Argentina that is run on an extremely populist platform. A few weeks ago, the elections in the Netherlands came in, where another extreme populist leader had been elected. And we are entering into an election year in the United States in which another extreme populist leader may be re-elected. And many other countries, including Israel, is not free from the phenomenon of political populism. Now, political populism has different manifestations, but by and large, it draws its power, it draws its logic, it draws its legitimacy, not from liberal ideals of equality and dignity for all persons within the jurisdiction, but from the idea that the politicians or the leader should should act upon the putative will of the authentic people, and that will is channeled from the authentic people to the leader, to the populist politician, and the populist politician is there in place in order to give effect to this will of the people, and to try to do that in the face of all sorts of actors within societies, elitist actors, such as judges, deep state bureaucrats, politicians that really serve according to the populist dogma, foreign agendas. So the populist leader, typically I should say, has to basically implement that will. Maybe, in France, maybe it's an exception, but is there to actually implement that will of the people and suppress all of these unelected elites that interfere, that come between the politician, the populist leader, and the real people, the authentic voice of the people. So this idea that there is us, the people, and them, the foreigners, the elites, the deep state, this is a very central feature of populist politics, which is often coupled by the rejection of norms of political civility which have been which characterize to a large extent more traditional forms of politics. Now, this worldview is a clear and present danger to the rule of law, because the laws themselves are sometimes that we have in place are sometimes regarded under this construction, under this worldview, as contrary to the true will of the people. And the institutions that we have to implement the laws are also seen as one barrier that sometimes need to be removed in order to give effect to the will of the people. And in light of that worldview, we are seeing sometimes very extreme, very problematic attempts by populist leaders or populist parties to pass legislation that goes against fundamental constitutional norms and chips away, erodes the powers of judicial institutions to basically curtail those putative wills of the people. We have seen this only in the last few days in the United Kingdom, for instance. I don't know if you've been following, but the UK government has put forward a Rwanda bill, a law that is designed to facilitate the deportation of asylum seekers from the United Kingdom to Rwanda without judicial review of their asylum applications in the United Kingdom, only a few weeks after the United Kingdom Supreme Court has held that such deportations would go against basic human rights norms and laws that apply in the United Kingdom. We have seen before that President Trump engage in a comparable policy with what was called the Muslim ban law, which provided for that restricted immigration or entry into the United States from certain Muslim countries. And when that law was struck down by a judge, Trump attacked the judge as curtailing the implementation of the policy and threatening that the judge would assume the consequences of the annulment of the law. And also in the corner of the world that I come from, in Israel, we have seen, and Professor Melman alluded to that, we have seen in recent years the current government in Israel, the current Likud government, basically attack the Supreme Court for even reviewing the legislation of the Knesset on basis of its compatibility with basic human rights norms, allegedly that such review goes against the values of Israel as a Jewish state. As part of this moves, we are seeing, like I said before, judges being portrayed by politicians, but also sometimes by the media as part of an elite which works against the interests of the people. So again, in the UK, during the Brexit debates and court proceedings, one of the tabloids has put a picture of Supreme Court judges on the front page with the headline, "Enemies of the People." And we have seen this animosity towards the judiciary also manifests itself in very concrete steps by populist or governments to take control over the judiciary in ways that would effectively neutralize them as an independent agent of a rule of law state. We have seen this happening in Hungary. We have seen this happening in Turkey. We have seen this happening in Poland, although maybe now it's going to be somewhat reversed, hopefully. And at least in Hungary and Poland, we have seen the European Union applying sanctions against both countries, explicitly citing the incompatibility of their policies with regard to the independence of the judiciary with the rule of law provision of the EU treaty. So actually, there has been a strong correlation which had been articulated between attacks on the judiciary and independence of the judiciary and the rule of law. Like Professor Melman said before, Israel has undergone last year a serious constitutional crisis. Now, of course, it seems as maybe the least of our problems, but it was and still is a very serious constitutional crisis. And at the heart of that crisis was an attack by the government on judicial power and judicial independence, trying to introduce an Hungary-Poland-like move to take over the judicial appointment process by politicizing the appointment of judges in the name of so-called democratic accountability. That is, that the composition of the bench would be more compatible with majority preferences. Also, at the same time, the government sought to limit the power of the judiciary to review government policy and to review the constitutionality of Knesset legislation. And also on top of this, so it's judicial appointments, it had to do with judicial review, but also to limit the power of another rule of law, what we call gatekeeper, and that is government lawyers, who in the Israeli tradition are independent civil servants who do not actually have their allegiance to the government, but rather to the rule of law and to the people. The idea was also to diminish the independence of government lawyers and also to render their decisions legally non-binding for the government. And the upshot of this judicial reform, had it passed, and in the end, so far it is only a small part of it had passed. The upshot of that reform is that it would effectively collapse the Israeli system of checks and balances between the different branches of government and would leave the ruling coalition in Israel in a position that they could pass any law that they wish. They can select the government lawyers that would interpret that law for the government. They would also, if there would be a challenge to the law before the court, the government would be in a position to select the judges who would hear that challenge and would take away from the judges the power to override these challenges. And even if at the very end, the court would strike down a legislation after passing through all these hoops, the parliament would have a residual power to override that court decision, and that would effectively result in Israel being no longer a rule of law state in an effective manner, but rather being a state that is ruled by law, which is something quite different, and that is the use of law in order to exercise power, and not the conceptualization of law as a significant restriction on power. It is not insignificant, I would note, and again, Israel is not the only country in which this is happening. The United States is also a glaring example that there is a very clear correlation between these reforms and such reforms and certain corruption trials that are taking place, including trials for abuse of authority, corruption cases like the one that President Trump is currently facing and that Prime Minister Netanyahu is currently facing, underscore a rule of law principle, and that is that no one is above the law. Everyone is subject to the law. The fact that while these leaders, and there are of course other examples such as Berlusconi, and one can think of other examples from around the world, that such leaders are simultaneously undergoing trials and eroding rule of law safeguards is probably more than just a coincidence. The judicial overall in Israel did meet a very strong pushback by civil society, and that is actually the one good takeaway that perhaps we can extract from that. It did underscore for many Israelis, and many Israelis were surprised to see how deeply embedded were rule of law principles within the broader society, and how quickly domestic society developed a sophisticated understanding of how very technical moves like changing the majority in this committee or that committee for electing judges which could seem like insignificant when viewed independently, actually could erode very dramatically the rule of law. So in that regard, we have seen a very significant defense of the rule of law by a very large constituency. We have also seen democratic and independent safeguards hold. So in Israel, the Supreme Court has pushed back and has struck down some of the laws that have already been passed. There is one significant case which is still pending, and we will see how the court will decide it. It has 1 month to decide the case, but most commentators expect the court to strike down the one part of the judicial overhaul reform that limited its own judicial review. And that, of course, would be a very important development. We have also seen in the United States how institutions withstood at least the January attempt to nullify the outcomes of the elections, although I would say only barely. So populism is one source for a threat to the rule of law. But one could say more broadly that situations of deep crisis are situations in which society's commitment to the rule of law is seriously tested. And there are some explanations, there are some reasons why situations of deep crisis more broadly are situations that present a serious challenge to the rule of law. First, there is a sense that extraordinary circumstances like wars or dramatic acts of terrorism, 9/11 types of terror attacks, or pandemics such as COVID-19, they require extraordinary measures. However, such measures might be incompatible with existing laws and even with existing constitutional or human rights principles, such as due process. And upholding such norms, especially when their beneficiaries are often very unpopular, so they could be foreign terrorists, or they could be enemy civilians, or they could be migrants, it's politically upholding their rights under these extraordinary circumstances is particularly difficult. And there is also this narrative that our laws never intended to apply in these circumstances. The legislature did not anticipate the problem, and that following scrupulously existing laws would be somewhat of a suicide pact. As a result, there have been attempts when confronting a deep crisis for many countries around the world to shake off some significant rule of law constraints. We have seen in the post-9/11 era the United States loosening its privacy safeguards. We have seen the United States in the 9/11 era loosening its habeas corpus protection, namely judicial review protection. And we have also seen countries around the world, like Australia during COVID, taking very extreme steps with regard to curtailing international travel. Times of deep crisis also put severe pressure on the judicial branch to take a step back and allow elected officials to take decisive action. Hence, we see this interconnection between crisis situations and legislation that is removing review power from courts. I've already mentioned the United States and its, well, I haven't mentioned military commissions, but cases involving 9/11 suspects were transferred from the ordinary legal system to a more government-friendly commissions, military commissions. And like I said, the UK Rwanda law that is now making is progressing, or we will see whether it's progressing through the political system, is allegedly responding to the immigration crisis. The boat people who are portrayed in the UK as this immigration out of control situation. We've also seen during COVID many very draconian steps that were effectively, including in this country, with regard to freedom of assembly, the ability to congregate, that have been effectively configured in a way that made judicial review only available on paper and not actually practically effective, something which the European Court of Human Rights has commented on. And finally, of course, crisis in itself fosters political populism. And we do see, again, a correlation between the rise of populists and very significant crisis situation in areas such as immigration, national security, but also, if we take, for instance, the Argentinian case, a very deep economic crisis. So when we are thinking about this connection between deep crisis and the rule of law, it is not surprising that when a country finds itself in a state of war, and Israel is currently in a state of war, it finds itself in this regard in almost a perfect storm from a rule of law perspective. An armed conflict situation is almost a paradigmatic case where the law struggles to effectively apply. And on top of all the considerations which I have elaborated and have discussed, one has to recall that when an international or an armed conflict between two political units takes place, the governing law is first and foremost international law. And international law, like Professor Melman has mentioned, is a body of law which has significant rule of law weaknesses, partly because of its weak institutional framework, the way in which it is created and the way it is enforced, but also the norms themselves that we have are notoriously open-ended, leaving it to the parties to the conflict often to make very important and dramatic determinations, such as what constitutes a target, a military target that that can be neutralized during wartime. What constitutes excessive damage? Now, I will emphasize that this is not what the law says. I mean, the law is objective; it applies to all parties to the conflict. But because of the weakness of the institutional framework that supports the application of the law, it is often left to the parties themselves to make these determinations, and it is very difficult for third parties to review these determinations and to uphold the law if these determinations were erroneously made. And that is, like I said before, because, like I said, international law lacks strong enforcement machinery. We do have, I should say, some enforcement machinery. We do have, of course, an international criminal court, which is situated in The Hague. But I should say that court only applies in extreme circumstances. Its ability to react remains quite limited. And even when it is confronting an extreme situation, its ability to exercise its jurisdiction effectively is also quite limited. There is another body that has another institution that has legal authority, and that is the Security Council, which could also introduce some important rule of law constraints in time of armed conflict. But as we have seen only last week, it's very hard for the Security Council members to agree on any important decision, and therefore its ability to actually enforce the rule of law remains extremely limited. I should also say that when it applies its decisions, it is often driven by mostly by political or geopolitical considerations and less by strictly legal considerations. Hence, as a rule of law institution, it is a somewhat problematic institution. Now, domestic courts do exist even in times of war, but their jurisdiction is often quite limited. They often refuse to accept jurisdiction over questions relating to active hostilities, There are problems of what is called legal standing, who can bring such cases. There are often not clear enough legal standards that could be invoked domestically by the court. And more generally, we see a phenomenon in which national courts often are reluctant to intervene in sensitive national security matters. Now, I should say that all of these weaknesses are not new. I mean, the observation that international law is weak and that international law of armed conflict is particularly weak is not a new observation. Already in 1952, Professor Hersch Lauterpacht, whose chair I'm proud to hold, at Hebrew University observed that if international law is in some ways at the vanishing point of law, the law of war is perhaps even more conspicuously at the vanishing point of international law. So we do have a serious problem of how do we apply the rule of law in times of deep crisis, such as the crisis that is currently pending in the Middle East in the context of the Israeli-Hamas war. I should say that Hamas, the other party to the conflict, operates altogether outside any legal framework, and in that regard, it does not regard itself in a meaningful way bound by any rule of law. Israel is different in the sense that it aspires to be a rule of law state, but like I insinuated before, it did respond to the Hamas attacks with very much legal flexibility, some say legal creativity, in target selection and proportionality analysis, and also with limited transparency and accountability, which renders it very difficult for outside observers or even observers without the country to meaningfully evaluate its compliance with the rule of law framework. I should say that the rule of law in such a conflict, which is an atypical conflict in the sense that it is not a conflict between two sovereign states, but rather between a state and a terrorist group or an armed militia, is also further complicated by the fact that there is broad disagreement between different states and different observers with regard to the applicable legal standards and applicable legal frameworks that dictate the rights and obligations of the different parties. And as a result, we are seeing a lot of allegations and accusations that are being made by one party or by one supporters of one position that are completely rejected as irrelevant and erroneous by the other party. And under these conditions, when you do not have widely acceptable legal standards that could be effectively applied to a concrete situation and cannot be effectively enforced, the rule of law in international affairs is under a lot significant pressure. So to conclude, in the end, the core issue concerning the rule of law, both at the domestic level and the international law level, has to do with the existence of professional, independent, and legitimate institutions that can create stable, accessible, and clear legal norms that can be implemented effectively and impartially across different situations. We are unfortunately at an historical moment in time where domestically we are losing trust in some of these institutions, whereas at the international level we are still struggling to create such effective institutions. And this renders the rule of law as a work in progress, something that is definitely worth fighting for, but something which would require a very long and hard fight to succeed. Thank you.
Thank you very, very much for the very, very rich input you gave us. I mean, myself, as a lawyer, I really don't know where to start exactly. So I imagine in the public there will be also lots of questions. So I'd like to start maybe with the rule of law, as we did, and also from the risk for the rule of law by populism. In what I never understood is why people don't see the internal clash that this concept brings, because putting the people, the real people, against the government, the existing government and the institutions that are working for the moment, those people who govern and want to change to a populist state, they are also a power. They are also not part of the people. So in a way, it won't work. So, I mean, how come that this contradiction stays hidden in a way? And it's not discussed? Or is it discussed? I mean, you're closer to the question.
Well, I would say rationality is not an existence condition of populism.
Mm-hmm. Yeah.
Mm-hmm. So I think that is something very important, I think, to understand about political processes, that is very much about certain emotions, certain attitudes, and I think you will miss the point of the incredible power of these movements if one just analyzes them in such categories of political rationalism. There's lots of things are irrational, and also this self-destructive element that I think you just hinted at. But that, I think, poses a problem that one has to solve.
So then, in a way, what happens in Israel, that masses of people really show it and point to the problem. That's a rarity. Is that very... It means that the people are very mature, in a way.
Yeah, I think the Israeli street protest was almost unprecedented in its duration and in the amount of people that basically went to the streets. I mean, this is not your ordinary situation, and this is why eventually the government slowed down the process of legal reforms and effectively settled for a very minor amendment, which I hope now will be revoked. But I think there is a question of who represents the real people. It's again, it's not an empirical question. It's a question of a certain feeling, and I think we shouldn't also ignore the fact that the political process and the political elites are viewed by many people around the world as not as having an agency problem, that namely not representing effectively their concerns. I mean, they are saying what they're saying in order to get elected. But once they are in power, they basically look out for their own class interests or group interests, and that is, I think, a sentiment which one cannot completely shake away. And in that regard, so I think what's happening in Argentina is very interesting, because Argentina is in a very deep crisis, and it is in a very deep crisis for many, many years. And the other guy who was running for election, who lost the election, was the Minister of Finance, who in a way was very much responsible for that economic mess. So the idea that things simply cannot continue as business as usual, that's a very strong sentiment that I think we as democracies have to find ways in order to deal with. I mean, it's not something we can simply brush off as you know, the populace getting crazy.
So in a way, the populists always have the easy part, because they somehow put the ear to the people and try to find out what's their real concern, what are their daily problems, and then they try to tell them, I am going to solve it. So that's about the mechanism.
Yeah, and that in itself, again, is not a bad idea. The problem is that it's not just this channel. It's not like this passive channeling capacity. a lot of the so-called problems are also fanned by the populist politics. So the populist politics also, in a way, sells the public the story, the narrative that they have been put down by certain elites. In Israel, you can see this quite clearly. We have seen in recent years a very, very aggressive campaign by the government and government supporters to divide Israel into first Israel and second Israel. So the idea is that the government, some of the elites, the judges, they come from first Israel, which means they are of European origin, they're well educated, they live in Tel Aviv, they like to sit in espresso bars and they drink coffee, and they are very far removed from the more blue-collar Israelis who are from the periphery and deal with very different sets of issues. And this has been a very aggressive campaign to create this significant societal divide between different peoples on the basis of their countries of origin, levels of religiosities, in ways which really tore the social fabric of the state. And part of what, I mean, I think there are a lot of people in Israel that believe, not only in Israel, that the war that we are seeing now is partly a result of this tearing of the fabric, which created a sense that the country is falling apart and therefore it's weaker than it was before, and this is now a good time to attack it.
I think what is kind of encouraging about this protest, and I said that in the German introduction, is basically that it shows that the rule of law, at least in certain basic respects, can become the object of game-changing political passions. And that is central. And to a certain degree, it's not surprising because the rule of law is not, has not been always there, but it is something that people fought for a very long time because there are clear points why you actually would like to have these things. And I think that is perhaps also important, that one doesn't fall into this kind of passivity to think there's no argument. I think it's very much possible to also make these points. They're perhaps a bit more complicated, but they can also have very considerable power. But I think we really have to make an effort to clarify what is at stake and why it is not an abstract thing, who rules, how the separation of power works, whether government is controlled, and which are the standards of control.
So I think also that's the most important, that what you said before about compliance, that the rule of law in certain states can be rather implemented in the people. They really understand it, and they have it like in the genes somehow. It came into their basic understanding of life and how it should be. And so in Israel, do you think the war now, the terrible times, will make a shift in one or the other direction, in respect to populism?
Well, one thing we see about populists around the world, that they normally don't know how to rule. They know how to get to power, but once in power, they often, because it's not a merit-based system, it's a system that is based on loyalty and identity. And that is typically not a good recipe for running a country, especially not a complicated country like Israel. But we've also seen, the Trump administration having its day, and we have seen, the voter in Poland have spoken a few months ago about the PAS record of achievement. So I think at least in the short run, I think that the politicians the populist politicians who are in power in Israel and have brought us to this point, it is quite likely that we will not see much of them going forward, this at least specific cadre, and that they will be, at least in the upcoming elections, they will be pushed back. But whether they can come back, I don't know. And the thing about the genes, I would like to believe that this is indeed something that is running in the genes, but I'm afraid that it also requires a lot of effort in the educational sphere. And I think, at least in Israel, but I suspect not only in Israel, civic education is in a very deep crisis. In schools, so the level of internalization of civic ideals is very limited because of a general crisis in the education system, a push towards other topics which are perhaps seen as more critical to the economy, and also concern by some teachers to speak about controversial topics like politics. So we are seeing, so actually for me, one of the takeaways from the deep crisis that we have undergone is that although we were saved that time, I believe, on the constitutional takeover front, we cannot be complacent about this, and we have to invest in civic education.
I think that's a very important point, because I think it's a big misunderstanding to think the rule of law is some kind of technicality which strange people who, because of some bad decisions in their life, spend all their time with the law, are dealing with, but which have no deeper roots. And I think that is a big misconception. And to create such an order is a great cultural achievement, and to maintain it is also a very substantial cultural achievement, which is not just done and, kept alive by explaining, what the exact system of the separation of power under the Federal Constitution of Switzerland is, or on the basic laws of Israel, and so on. It is about understanding the kind of human point behind that, and the interpretation of our own, in a way, living together, and what kind of demands that creates, that I think has to be kept alive. And therefore, I always thought that it's a bad thing if law and the thoughts of law are somehow isolated from these more wider cultural discussions. And sometimes the lawyers are at least partly guilty, because they are perhaps too lazy to do this other work. But it's also a question about, let's say, the civil society and society at large, how interested people are to actually hear something about that.
Yes. So I think the whole democratic discussion is a cultural one. It's not merely a legal one. Because, and what was lacking in the discussion in Israel, I thought, was that democracy was merely like a numeric concept, and it has no content. And I think without content, democracy loses all its value. The idea is that it has the rule of law, those basic human rights that we understand. And I think there is a big discussion also in culture, in literature, about dignity of people, human dignity, and equality, equal rights. I think those concepts, they are widely known, but maybe they're not really, the link is not made to the law, maybe, with the people in general. So maybe that's the task, to make people or young people think about how important it is that you have a legal body that helps to maintain all those basic rights, because that makes the quality of the life, I think.
No, I agree fully with what you said. Maybe I'll note two things. First, in Israel, also the government, I should say, they advocated that the reform is a democratic reform. So the reform was supposed to restore democracy. Democracy was stolen by the courts. It was stolen by the legal advisors, it was stolen by the bureaucrats, and now we are restoring democracy. So everyone is talking about democracy, but of course the question is, what do you mean when you say democracy? What do you actually mean? Is it only majority rule and a winner takes all approach to democracy, or does it also have all the other aspects, such as human rights, the rights of the minority, rule of law, independent judiciary? And the other thing is, and that really ties into the point that Matthias Malman just said, the legal community in Israel was, I should say, organized very quickly when these reforms were starting to unroll. And many of my colleagues, and also I was also involved in some of these initiatives, we actually did, we were not lazy, and we did actually embark on a lot of outreach activities. So a lot of actually lawyers were basically, what they did was actually go from house to house, basically have like meetings in living rooms with like 10 people, 15 people, and also engaging in a very active outreach activity in digitals, in all sorts of digital platforms, and also do a lot of media interviews in order to underscore and the amount, and what is actually encouraging about this story is that the amount of constitutional literacy that developed in the country within very short few months was quite amazing, because after, I mean, when it started, no one knew anything about judicial appointments. And now you could actually hear 3 months later people who are not lawyers discussing whether this majority or that majority in the appointments committee would imply this. So people really understood what it's about, which maybe is depressing for us lawyers. It's not rocket science. You can explain this quite clearly and quite quickly to a very large audience.
Not everything.
Okay.
Yep. So I think it was worthwhile already coming here to get some hope from you, which you gave us by telling us how people really develop into the right direction and start to understand. But what strikes me is that there must be something like a zeitgeist that creates a risk for democracy in the real sense of the rule of law, with including the rule of law. And I don't really know how one can explain that, but when I was little, that there was no such, nobody would ever have doubted about human rights, about independence of the powers and so on. And all of a sudden we see it all over. So is it something like contagious, or does it start somewhere and it's imitated, or I don't, the problems are so different in all those different countries that I really don't understand why it's an overall, almost overall Erscheinung, overall phenomenon, yeah.
Yeah, so there are many explanations, but maybe let me try 3 explanations which quickly I can think of. And that is, one, it's a generational thing. In the sense that, I mean, the story of human rights in Europe is a story of the post-World War order. I mean, people who are who remember or at least went to school and studied about the world before 1945, they had a strong attachment to human rights. They had a strong attachment to European integration. I mean, the farther you are away from time, these stories look like, the Middle Ages. This is like a very distant past. So the trauma that, in a way, has given impetus to this post-World War, rule of law, human rights, democracy, European integration picture. I don't know if I can speak about this in Switzerland, because Switzerland is in a unique position, but by and large, it is part, of course, of the broader European family. The farther we are going away from that point in time, I think the weaker is the historical lessons of that point in time, and that may also have to do, with our education system and our ability to convey to generation after generation what it means to live in a world without all of these things that, I mean, young kids take for granted. Secondly, there is this issue of the economy. The economy is very bifurcated or multi-leveled, and what is working for a lot of people is not working well at all for a lot of people. A lot of people don't have good jobs and don't have good prospects, and they don't think that the status quo that is built on all of these ideals and institutions works in their favor. And this is generating a lot of discontent and malaise, and is serving as feeding ground for these populists who always can identify who is to blame for all of these problems. It will be the immigrants or the EU or the United States or Israel or the Jews or what have you, or the left or the elites. The list is very long and it's not exhaustive. And the third thing maybe is technology. And technology, and especially social media, is changing completely the terms of the political debate. What we are talking about, Professor Mellman explained, these are very nuanced ideas. This is a very delicate balance between power and accountability, between legality and democracy. And it's very hard to twit. It's very hard to twit these ideas or to condense them into 257 letters or what have you, icons that you have. So we are living in an era where the attention span of people who are living on social media is extremely short. So if you cannot actually convey your message in a TikTok clip, then you have lost the battle. And populist messages are much easier to convey. They're simple. They're straightforward. It doesn't take a university degree in law or philosophy to understand them. And of course, the more we are reliant on technology, the more we will see, I think, this challenge increasing.
Perhaps one could add one thing, which is also important. I mean, the horrible political movements, the violent political fanatism of the 20th century, it was not just an historical accident. But there were deep reasons for that, and there were presumably also profound reasons for its considerable appeal. Yeah. So I think to be told that one is part of a particular group, that one lives in a hierarchy of human beings, so that one is better than others, is something that I think has had enormous traction, and I think it still has traction. I think one also has to factor in that this appeal worked in the past and works today in, very different ideological, political, and sometimes even religious contexts. And I think we need a counter story. Yeah. You need to tell a story that explains why, at least in my world, I have the slightest wish to feel any better than anybody in the room. I'm pretty happy just to be kind of an equal.
Yeah. So I think the time is running out. So maybe we'll open the floor to one or two questions. Do we have time for that? Okay. So if there are questions. Huh? What? No questions? Ah, yes, okay.
Vielleicht können wir das Mikro, wenn Sie mir das kurz leihen. Bitte schön.
So, danke vielmals. So, thank you very much for your grand, wonderful talk. And you talked especially about the rule of law on a national level, and so especially in those times, I'm also interested in the rule of law on the international level. We notice some perplexing incidences on the level of UN Security Council, and also UN, like UNRWA, and we get the feeling that often they also reflect more geopolitical interests than rule of law. We notice double standards almost every day, and how are these institutions bound to rule of law?
Yeah, I mean, I think as I said in my speech, the rule of law is a work in progress, certainly in the international sphere. I would say that within the international sphere, we have pockets of rule of law. I mean, there are some areas where on a regional level or in a specific subject matter level, we were able to create these sort of independent, professional, effective institutions that are able to interpret and apply the law. So Judge Keller was here before. She was on the European Court of Human Rights. the European Court of Human Rights, not a perfect institution, but it is a strong rule of law institutions that is, I think, quite effective in what it does. I had the honor and privilege, like Professor Keller before me, of sitting on the Human Rights Committee, not Council, the Human Rights Committee, which also tries to, I think, very hard, and I think has done quite a good job in upholding human rights in an objective, professional, and effective manner, despite the many challenges that it had faced. But this is not the case across the board. So if you're talking about the UN Security Council, it's a political body. It is not really a law-applying body, and therefore the expectations that it would be a strong rule of law body are very limited. The same would go for the Human Rights Council, which is a political body that applies, let's say it deals with human rights, but it often applies human rights in the furtherance of a political agenda, and not vice versa, apply a political agenda in the furtherance of human rights, as you would have expected. I think there is a concern, and many people are concerned, myself included, with the professional agencies of the UN, who you would have expected to be to represent a better model because they are professional and because they are supposed to operate in an independent and impartial way. But again, some of them are doing a very good job, but some, and I'm afraid that in the recent conflict, some of them have really become not lived up to the ideal of impartiality, objectivity, and professionalism in the work. I should say that some of them still are doing, even within the conflict, are doing very important and life-saving work. So I don't want to castigate I think you really have to look at organization by organization, and sometimes even within organizations, different office holders and different segments. But to say that the overall picture is rosy, no, it's far from rosy. It's actually quite disconcerting.
And if I may add one thing, I just had a seminar with an English colleague who's also actively engaged in litigating against some of the stuff that is going on in the UK. And one of the things we were wondering about is why does the current government in England think that violating and actually derogating from human rights sells politically? And that is also a question that has to be asked. It is not only about the institutions, it is also about us, the persons who elect certain people on certain grounds. And it is clear that somehow we are in a situation where people go around and think they will only win if they are selling, for example, a weakening of the international human rights system. And that is also an answer to what do we do about selective application and strengthening. We can at least try not to weaken those systems with our own political preferences. And I mean, to the honor of Switzerland, we had some initiatives which tried to do that, and they lost. And I'm personally very proud of that.
You mean referendum initiative?
Yeah.
Okay, yeah. I'm aware.
So by popular vote.
Okay, I think we have to. Time is over. More questions? Okay. Please.
I think the elephant in the room is the actual situation now. And we've been talking a lot about the rule of law, and I would be very interested to hear your opinion about where Israel's activities at this moment stand when it comes to the rule of law. You've said that Hamas functions completely outside of any legal concepts, but what's happening?
Well, like I said in my remarks, I think it's hard to say what is happening on the Israeli side. So I can tell you that Israel considers itself bound by the rule of law and has a rule of law apparatus. So every decision to target this or that building would be a decision that would go through a lawyer, that would authorize the decision. So in terms of having the structures in place, the structures are in place, to the best of my knowledge. The outcomes are very difficult. We are talking about extensive harm to property and, more seriously, extensive levels of casualties. So one has to ask, is this because targets have been selected in a careless way or in ways that do not meet international standards? Has the proportionality analysis, you can target under the laws of war if there is no excessive collateral harm, whether this has been applied properly, whether the precautions that were given were effective precautions, whether the restrictions that were introduced on access to humanitarian services, were they justified or excessive? And the truth is that we know very little at this point in time. But I think it is right for us to be concerned and to ask these questions. Because although, like I said, you do have the framework and you do have the infrastructure, the results appear to be quite more than unfortunate, quite distressing. So I think we should ask these questions very seriously. On the other hand, I would say that I would be also somewhat hesitant to jump into judgment just on the basis of the fact that there are many, many civilian casualties. This in itself it is terrible, clearly, but that in itself does not necessarily imply illegality, but it raises concerns or suspicions of illegality that must be investigated.
There were more questions, I think, before. Yes?
Aber wir sollten jetzt irgendwie, weil wir hier mal raus müssen. Frau.
There's the old saying that every country gets the rulers it deserves. But seriously, how do you solve the enigma that the populist rulers you were mentioning before were elected in a democratic manner by the very populace, which is the essence of democracy? It's somewhat patronizing for us in other countries to point at these people like Trump or Netanyahu and Erdogan or you name it and say these people shouldn't be where they are. But the fact is they are there because their nationals voted them in. So how do you solve this enigma?
I would say, nobody has ever thought that democracy necessarily produces wise decisions.
It's a flawed concept.
No, not democracy is a flawed concept. It is just a risky enterprise. And it has lots of preconditions. The Athenian democracy was a kind of limited democracy, but it was, in that context, something like that, which didn't stop this interesting political entity to start and conduct a self-destructive war. So it's as old as democracy is the danger that democracy destroys itself. That is the risk that we are taking when we are embarking on this project. And therefore is that what we are talking here about, not a soft topic. That is the infrastructure that is central. There was a famous philosopher, you certainly have heard him, Ernst Cassirer, who wrote a very interesting book in exile and then published in the post-war period, The Myth of the State. And he said the ultimate safeguard against fascism, against dictatorial regimes, is what he called, quote, the inner constitution of the citizen's mind. So the ultimate safeguard are not courts, not buildings, not police, but what is going on in the minds of everybody here at the end. What are our values? What is what we want to defend? What are our passions? What are our red lines? What kind of character do we have? How important is democracy for our quality of life and our own identity? That are the hard questions, and that is why I think such things in the messy ways in which we conduct it are so important, and therefore why all citizens, everybody is so important.
Let me just add, I think there are two separate concerns. who is getting elected, of course, that's a matter of preferences, and you can be critical about crowd wisdom, etc. I think for me the most concerning aspect is once they are elected, what happens then, and why they are then keen on basically dismantling the existing safeguards that basically allow them to get elected. So a populist like Erdogan, the concern is not just that Turkey has elected a person like Erdogan, is that once Erdogan is in power, that he will ensure that there will not be any chance that he will be kicked out of power. So the idea is that these populists, because they empirically many of them are also quite bad rulers, they invest a lot of time and effort in ensuring that the next elections would be much less competitive, and that the checks and balances that have been relevant for the previous administration would not be relevant to them. And I think this is the second and separate concern, which you can oppose regardless of what you think about Trump or Netanyahu or whoever has been elected democratically.
But Trump was voted out, and sadly, he might be voted in again.
And if he will try again to dismantle American democracy as he has done and almost succeeded around the January 6 events, I think there will be a lot of concern by people in America and around the world for this, despite the fact that he has been elected democratically.
Okay, last question.
Thank you. I want to ask you something about the trade-off. There's a trade-off between democracy and the law of rule, and there's also a trade-off between security and the rule of law. So when you only talk on the rule of law, it's a problem because we also need to fix the problem democratically, and this is in a trade-off. Could you please clarify?
So the question is whether there is a tension between security and the rule of law. So I do not advocate that countries that are facing existential problem will conduct themselves in a business as usual state of affairs. But this doesn't mean that you go to the extreme and that you abolish all rule of law institutions. So many countries have emergency power structures. Israel is an example of a country who's been in a state of emergency since 19th May 1948. Okay, so it's been in a perpetual state of emergency, and that is also a rule of law framework. It's a problematic rule of law, but maybe, I'm not sure it was justified throughout the history, but now it's probably justified, that you would have some procedural shortcuts for passing legislation because of the time of emergency, and that you may be able to derogate. This is also under international human rights law. You are able to derogate in times of emergency from certain human rights protections. We have seen this during COVID, that many basic rights have been suspended or significantly limited. But I think it's important that even within that framework, you try as hard as you can to operate within a rule of law framework and with some institutional safeguards, because under these security conditions, the potential for abuse is, of course, extremely high.
I would like to add one thing, and that is, I think that there is no simple tension or opposition between the rule of law and democracy. Democracy is about organizing political autonomy of individuals. And democracy must be a structured, ideally permanent enterprise. And part of the normative structure, the normative architecture of democracy are legal rules, are rights that protect your freedom of opinion, your freedom of assembly, other fundamental rights, procedures to actually organize elections, norms that enable you to control certain things. So I think, democracy cannot be just some kind of unstructured utterance of a will, but it must be a highly structured organization. And that is where the connection and the necessary connection between the rule of law and democracy arises. You will not have structured exercise of political autonomy, and that is democracy, without the rule of law.
Okay, thank you very, very much. I think we learned an awful lot, and we could go on discussing and asking questions for like 2 or 3 weeks. But I thank you very, very much for the many things we could learn tonight. I could learn tonight, and I wish you a wonderful evening. For the rest, I think Nadia wants maybe to tell something.
Thank you. I also want to thank you, Vera, and Yuval, and Matthias, and particularly also the public for being so attentive and following the presentations and the ideas. And somehow we get back to this fact that education leads to democracy, and it's always connected, seems to be connected to education, how you can live in a society, in a democratic society. You're most welcome to join the apéro, and thank you again for coming.
Thank you.
Thank you very much. Thank you. I mean, you handled this very well.